Welcome back, everyone. Let's energetically start the fifth session here at 2024 ICAO Legal Seminar. The fifth session is going to dwell upon the current issues in aviation law and practice. And this session is going to be led by Ms. Xiu Hui Tan, who is the Director of Civil Aviation of Singapore and also the Chair of ICAO Legal Seminar. Let's welcome her to the stage with a big round of applause. And for this session, we're going to be joined by two distinguished speakers. First of all, let's welcome Mr. Yao Nampong, the legal officer from the Legal Affairs and External Relations Bureau at ICAO. Welcome. And let's bring on to the stage Mr. Lee Keun-yong, the president of the Korean Society of Air and Space Law and Policy. Let's welcome him with a big round of applause. Yes, now I'm going to leave it up to our moderator to lead the session.
Thank you very much. 안녕하세요. Good afternoon, distinguished ladies and gentlemen. First of all, I would like to thank ICAO, and in particular Mr. Michael Gill, and the government of the Republic of Korea, especially Minister Park, for inviting me to participate in the seminar as a moderator for this session. This session on the current issues in aviation law and practice will cover two major matters. First, updating the rules for the settlement of differences under the Chicago Convention, to be presented by Dr. Yao Nampong. And the second, how the Chicago Convention has worked for the last 80 years. We have up to 3:30 p.m. for this session, about 1.5 hours. The first presentation will cover the work of the working group for the review of the rules of the ICAO rules for the settlement of differences, also known as WG-RRSD. This working group, established by the ICAO Legal Committee in 2019, owes much to Dr. Yao Nampong's contribution and support as a member of the ICAO Secretariat team. The Legal Committee will deliberate on the working group's proposed revisions to the ICAO rules at its upcoming 39th session this June. Dr. Nampong's presentation will assist states to prepare for this priority work item of the ICAO Legal Committee. Dr. Nampong is a legal officer in the ICAO Legal Affairs and External Relations Bureau. Prior to joining ICAO in 2016, he served as a senior legal officer with the African Union Commission. His areas of specialization include air and space law, public and private international law, international administrative law, commercial law, and dispute settlement. He is given the greater amount of time for presenting in this panel. And questions and answers can be addressed to him immediately after his presentation. And the reason is because the two topics are kind of different. And after that, I will introduce Professor Lee for his presentation, but it will be preceded by a rather long introduction on my part, and I will explain when we come to it. So, Dr. Nampong, please. Thank you.
Good afternoon, everyone. Let me begin by expressing gratitude to the Ministry of Land, Infrastructure and Transport for the invitation to participate in this seminar and for the warm welcome and the warm reception that you have given to us during our stay in Korea. This is my second time here, and it gets better every time, so thank you. I will be addressing in the next few minutes the work that has been done by the working group for the review of the ICAO rules for the settlement of differences. This, as the moderator indicated, is a working group of the legal committee of ICAO, which was established specifically to review the ICAO rules for settlement of differences. Of course, in an ideal world, we would hope that there are no disputes between states, right? But we do not live in an ideal world. And so, despite our best intentions, disputes do arise between states. And so there is a need for mechanisms or a mechanism to address those disputes, particularly those pertaining to the interpretation and application of the Chicago Convention, which I'm sure you've heard so much about in the last few hours. So I will, in traditional aviation format, pretend to file a flight plan for this flight, which you see on the screen. Unless there are, severe objections to this flight plan, I will consider that it has been approved, and we will start our takeoff roll, and hopefully we will land when we get to the next steps. Okay, so seeing that nobody has raised their hand to object, the flight plan is approved. So we'll look at the dispute settlement functions of the Council. We will look at the cases that the Council has dealt with or is in the process of dealing with in its 80-year history. We will look at what rules we are talking about, the rules for the settlement of differences, the establishment and the mandate of the working group that I referred to, the methodology that has been followed by the working group. I will give you an idea of some of the proposed revisions to the rules that the working group has come up with, as well as the substantive issues that the working group considered but did not make any proposals with regard to amendments. And then we would then look at the next steps in terms of where we go from here. So you will notice right from the beginning that I'm not talking about the judicial or the political function of the ICAO Council, but I'm referring to the dispute settlement functions of the Council. Article 84 of the Chicago Convention specifically says that if any disagreement between two or more contracting states relating to the interpretation or application of this convention and its annexes cannot be settled by negotiation, it shall, on the application of any state concerned in the disagreement, be decided by the Council. It continues, but I will not quote the entire provision. So, to start with, the dispute settlement functions of the Council are specifically related to disputes or disagreements relating to the interpretation or application of the convention, the Chicago Convention, and its annexes. And there is a requirement that those disputes cannot be settled by negotiation. And once you meet those conditions, then you can file an application before the Council to have that disagreement settled. Of course, as a fundamental principle of justice, no member of the Council is allowed to vote in the Council's consideration of any dispute to which it is a party. It's a simple principle of, no one can be a judge in their own cause. A decision made by the Council can be appealed either to an ad hoc tribunal agreed between the parties or to the International Court of Justice. I mentioned that the Article 84 specifically refers to disputes pertaining to the or relating to the interpretation or application of the convention, but similar functions are conferred upon the Council in relation to the International Air Services Transit Agreement and the International Air Transport Agreement, both concluded in 1944 by virtue of Article 66 of the Convention. So Article 66 basically says that the organization shall perform those functions that are conferred upon it under the Transit Agreement and the Transport Agreement. And those functions include settling disputes that arise in relation to those treaties. So again, pardon me if you cannot read these slides. The intention is not to make you squint or to force you to wear glasses prematurely, but it's just to give you a very high-level summary of the cases that have been handled by the Council over its 80-year existence. So the first case was filed in 1952 by India against Pakistan. It concerned the establishment by Pakistan of a prohibited area along its western border, which made it difficult for Indian aircraft to fly over Pakistani airspace into Afghanistan. Sorry, my screen went blank for a moment. I wasn't sure what was happening. The provisions of the convention which were implicated were Articles 5 and 9, as well as the transit agreement. The second case, 1967, was between the UK and Spain. Again, it concerned the establishment of a prohibited area close to Gibraltar Airport, which the UK complained made takeoffs and landings from that airport unsafe. The third case, actually two cases, were filed in 1971 between Pakistan and India. Again, Article 5, the right of non-scheduled flight, as well as the transit agreement. It's interesting to note that in that case, there was a preliminary objection filed, and the Council's decision on that preliminary objection was appealed to the International Court of Justice, and it was upheld by the International Court of Justice. The next case is from 1996, Cuba and the United States. Again, it related to the right of Cuban aircraft to overfly US airspace during their flights to and from Canada. Again, Article 5 of the Chicago Convention. Up until then, Articles 5 and 9 seemed to be quite problematic for states, and so many of the disputes revolved around those articles. Fast forward to 2000, we have a case involving the United States and 15 European states. This was in relation to the hash kit rule. The European regulations basically were more stringent than the ICAO standards relating to noise certification of aircraft. And this made it impossible for certain US aircraft which had been equipped with the hash kit rule and which complied with the ICAO standards not to operate in the EU. The more recent cases start from 2016. Brazil and the US is still a case that is pending before the Council in certain respects. It relates to the interpretation and application of the Convention and its annexes following the collision in 2006 of a Boeing 737 aircraft operated by GOL Airlines and a private jet and Airjet Legacy Embraer operated by XL Air Services Incorporated. It related basically to the interpretation and application of Article 12 of the Convention. In 2017, two cases were filed, which I'm sure many of you are aware of, by Qatar against Egypt, Bahrain, Saudi Arabia, and the UAE in the first case, known as Application A, which related to the interpretation and application of the Chicago Convention. And then the respondents in the second case were Egypt, Bahrain, and the UAE, and this related to the transit agreement, the right of overflight. The action has been discontinued against several of the respondents, but it's still pending in certain respects before the Council. In 2022, we received an application from Australia and the Netherlands against the Russian Federation, and this concerns the shooting down of flight MH17 in July 2014. This is still a live matter that is pending before the Council. After that, we had the Russian Federation filing a claim or an application against 37 member states of ICAO, alleging that these 37 states had taken unilateral unlawful measures in contravention of the Chicago Convention. This is still pending again before the Council. We have the most recent case, Canada, Sweden, Ukraine, and the UK against Iran from 2024. This concerns the shooting down of Ukraine International Airlines flight PS752 on 8th January 2020, and the provision of the convention which is implicated is Article 3 bis. So these are all matters which are pending before the Council, and so I would not go into any further detail. But if you have been following this, your states have been notified about the receipt of the applications and where we are in these matters. So Article 84 of the Convention and Chapter 18 of the Convention, which deals with disputes, does not set out any procedure for the Council to handle applications received from states under Article 84. So when the first case was filed by India against Pakistan, there were no rules. And the Council decided then that it was important to have specific rules to help it resolve those disputes. And so it appointed a group of experts which deliberated and came up with rules which were adopted by the Council in 1957. Ever since those rules were adopted, they have only been amended once in 1975, and that amendment was simply to include Russian as an ICAO working language in the rules. Those rules apply to disputes submitted under Chapter 18 of the Convention. They define the procedure to be followed by the Council when it engages in the settlement of differences under Chapter 18. This process involves submission of written pleadings or written documents by the parties, as well as oral hearings. An important aspect of the rule is that the rules is that they encourage and facilitate the conduct of negotiations at all stages during the proceedings before a final decision is rendered. Of course, there is an ongoing process to review the rules, which is being carried out under the auspices of the legal committee. And this is the purpose of this presentation is to give you an update of the work so far done. It's important to note that any rules, any revised rules that are approved by the Council or adopted by the Council as a result of this process will not apply to any of the pending cases unless the parties agree specifically to that effect. So the working group on the review of the rules for settlement of differences, known in ICAO, we like our acronyms very much, so this group is known as the WGRRSD. The establishment of that group takes root from a Council decision in 2017, where the Council tasked the Secretariat to begin the process of reviewing the rules. Now, following consultation, it was agreed that the item would be added to the work program of the legal committee, and this decision was made during the 37th session of the legal committee, which was held in 2018, September 2018. So along with that decision, the legal committee decided that a working group should also be established to carry out the review, to start the process of the review, and that the members of that working group would be nominated by the chairperson of the legal committee in consultation with the president of the council. So ultimately, the working group was established in May 2019 and has been at work since then. So between May 2019 and April 2024, or should I say September 2023, the working group has held 8 meetings in Montreal. So during that period, the COVID pandemic broke out, and so the working group had no option but to transition to a virtual format. So 4 of the meetings were held in virtual format, and 4 of the meetings were held in person. The membership is from 23 states, nominated by the chair of the legal committee in consultation with the president of the council. The chairperson of the working group is Mr. Terry Olsen from France, which is one of the members of the working group. We had a vice chairperson, Ambassador Jailani from Indonesia, but he had to be replaced as he was no longer appointed as an expert on the group. So with effect from the 5th meeting, Mr. John Thatchett of Canada has been the vice chairperson of the working group. The group, with the endorsement of the legal committee, appointed a rapporteur from Singapore in the person of Mr. David Lowe. At the 8th meeting, the working group considered that it had completed the work that had been assigned to it, and therefore it adopted a final report which would be presented to the legal committee at its upcoming 39th session in June 2024. Now, appended to that draft report is a set of draft revisions to the rules that the working group proposes for the consideration of the legal committee. Now, in terms of methodology, the working group had the benefit of many benchmarking studies and research done by the Secretariat to identify different practices, relevant practices of international dispute settlement bodies such as the International Court of Justice, those named there, ICSID, the International Tribunal for the Law of the Sea, the Permanent Court of Administration, the UN Commission on International Trade Law, and the World Trade Organization. Now, during the course of its work, the Qatar cases, the Council made a decision on the preliminary objection or preliminary objections in the Qatar cases, which were appealed to the International Court of Justice. And the International Court of Justice pronounced itself in July 2020 while the working group was still carrying on its work. And there are several instructive pieces of information from those judgments which the working group took into account in the conduct of its work. The working group also had, after many policy discussions, drafting proposals prepared by the rapporteur and the Secretariat, which were subsequently discussed and either approved or rejected. So in the next few slides, I will try to give you a taste of some of the revisions, proposed revisions to the rules that the working group came up with. So the first one is, of course, the scope of application of the rules for settlement of differences. As I have mentioned, Article 84 says that the Council shall decide any disagreement pertaining to the interpretation or application of the Convention and its annexes. But then we realize that there are other conventions. So we have the Chicago Convention, the Transit Agreement, and the Transport Agreement, or the Chicago Acts from 1944, falling within the scope of the rules. But we do realize that there are other treaties, other international treaties that have conferred dispute settlement functions on the Council. For example, the joint financing agreements between Denmark and Iceland, the Den-ICE agreements, for example, confer certain functions, dispute settlement functions on the Council. So the question was, do we expand the scope of the rules so that the Council can apply the same rules when it is seized with a dispute arising under those other treaties which are not specifically referred to in the Chicago Convention. There were extensive deliberations on this subject, and in the end, the drafting proposal that the working group came up with allows the Council somehow to extend its jurisdiction to these other disputes, but on condition that the Council has expressly granted its consent to undertake those dispute settlement functions. So ideally, when that treaty is concluded, the Council should be involved in the process and should agree to accept dispute settlement functions. In other words, two states cannot set up a treaty and just between the two of them say that the Council will be responsible for deciding any disagreements that arise under the convention without the Council's agreement, and then that confers jurisdiction on the Council. So, but even with that drafting proposal, and I apologize that the drafting proposals do not appear on the slides, what will happen is that the report of the working group, along with the drafting proposals, will be published as a working paper for the upcoming legal committee meeting. So it will be accessible to everyone here. I encourage all of you to look out for it and to read it so that you are familiar with the proposals that are presented therein. But in the end, within the working group, there was a divergence of opinion. There wasn't consensus achieved on it. So the drafting proposal is placed in square brackets, and it is hoped that the legal committee, when it considers it, will be able to come to a decision, a final decision on whether to retain it or to jettison it. There are several other revisions, proposed revisions, which are aimed at just modernizing the rules. So for example, the current rules require that the agents for the parties must have an address at the seat of the organization. By an assembly resolution, the seat of the organization is the city of Montreal. So if you become party to a dispute and you appoint an agent, your agent must have an address, basically a physical address within Montreal. This can be a problem for some states that do not have resident delegations at ICAO headquarters. And also it could pose a problem because, I mean, in this day and age, documents are not sent exclusively by mail. So there was the need to modernize provisions, relating to these things by including the possibility for agents to have electronic or email addresses. In fact, today, when documents are sent in hard copy, we follow them up. Actually, we send them electronically before we follow them up with the hard copies. So this is just to catch up with what has become the practice today. There are a bunch of other amendments that are basically intended to reflect the principle of gender neutrality across the rules, across different linguistic versions of the rules. So, for example, you would see if you read the current rules that it makes reference to chairman, and there are gendered pronouns. If the respondent wishes to file a preliminary objection, he shall do this. So there's been proposed revisions across the board to get rid of these gendered pronouns and to make the language, the text of the rules, gender neutral. Again, similar provision to, similar proposals to those pertaining to email addresses and things of that nature. The rules require that documents must be filed, but they do not say that they should be filed in hard copy or electronic format. In reality, we do receive them in hard copy and in electronic format. So these amendments are intended to update the rules so that at least there is a legal basis for submitting an electronic format of a document. But noting also that we're dealing with legal proceedings, the working group thought that it was necessary to keep the old provisions which require hard copies to be submitted because you need to, at some point, be able to check the authenticity of documents that are submitted in these proceedings. In Article 2.1g of the rules, you will find that there is a requirement that when an application and a memorial are filed, they must contain a statement to the effect that negotiations have been carried out and they have not been successful. Negotiations to resolve the dispute have been carried out and have not been successful. Now, from the Secretariat's perspective, this created quite a bit of a problem because it is not clear whether the Secretariat is supposed to find out whether indeed these negotiations have taken place and have not been successful. Because when you read the rules, the Secretary General is supposed to verify that the application complies in form with these requirements, and this is one of the requirements. And when you read Article 84 of the Convention, it uses slightly different language. It just says that the application, the dispute or the disagreement cannot be settled by negotiation. So the proposed amendment, the drafting proposal, is aimed at aligning Article 2.1g with what is in Article 84 to make sure that the language is basically the same, to say that there must be a statement that the dispute or the disagreement cannot be settled by negotiation. And then things move on along those lines. The rules presently say that a preliminary objection may be raised if the respondent questions the jurisdiction of the council to handle the matter presented by the applicant. Now, in the ICJ judgments of 14 July 2020, there was an express decision by the International Court of Justice to the effect that preliminary objections may also be raised on grounds of admissibility of the claims. And so there is a drafting proposal to reflect that decision of the ICJ and to include admissibility expressly as a ground for preliminary objections. There are other proposed amendments. The rules currently as they stand do not make provision for the filing of written documents after a statement of preliminary objection has been filed. So what the practice in the organization has been to allow the other side to file written comments in response, and on occasion there's been replies and rejoinders and on and on. So the drafting proposal in the rule would be to give the opportunity for such written comments to be filed and no further pleadings in relation to the preliminary objection to be filed unless otherwise decided by the council. This is intended to provide clarity to the parties that you have only one round of pleadings, because there's been occasions in the past where just the written proceedings on a preliminary objection have gone on and on and on, and this has led to questions being raised about whether the council can actually have the opportunity to resolve the dispute or not. There are other provisions pertaining to whether or not negotiations may take place once a preliminary objection has been filed. Because when you read Article 5.4 of the current rules, they provide that once a preliminary objection is filed, no further steps shall be taken under the rules until it has been decided by the council. Meanwhile, in Article 14 of the rules, the council has that authority at any time to invite the parties to enter into negotiations. So the question is, when a preliminary objection is filed, does it mean that the council cannot invite the parties to enter into negotiations, or the parties themselves cannot enter into negotiations? The drafting proposal makes it clear that irrespective of whether or not a preliminary objection has been filed, the parties can still negotiate and resolve their disputes themselves, or the council can invite them to do so without infringing the rules. There is a provision in Article 18.2 which says that once a party decides to appeal against a decision of the council to the ICJ or to an ad hoc arbitral tribunal, this must be notified to the council within 60 days. Now, the question has been, what do you notify to the council within 60 days? Is it the actual appeal that has been filed or an intention to file an appeal? Again, there was long deliberations, extensive deliberations on this, and the working group concluded that the intention is that the actual appeal must be notified to the council. So the drafting proposal introduces language to make sure that it is the submission of an appeal which must be notified to the council within the 60 days, not an intention to appeal, because you can intend to appeal and not appeal for 10 years. Article 29 of the rules sets out the languages within, in which the submissions may be made to the council. The sad reality is that even with the amendment in 1975, Article 29 refers to the 4 working languages of the organization. Currently, the organization has 6 working languages, so the proposed amendment is intended to avoid using a number to refer to the working languages, so that in the event that, let's say, in the future, the working languages are more than 6, there would be no need to amend the rule, and it would be flexible enough to take into account all these changes. There's also a practice that has crystallized, in the council's settlement of disagreements, basically to the effect that when pleadings and documents are submitted, only the actual pleadings will be translated into all 6 languages and not the supporting documents. Usually, the pleadings themselves are quite concise, but the supporting documents can easily run into thousands of pages. And if we have to translate all of them into all 6 ICAO working languages, you can imagine the financial and logistic challenge that would pose to the dispute settlement function. So the council decided that only the actual pleadings will be translated and not the supporting documents, unless, of course, the Secretary General decides otherwise. This is reflected in a drafting proposal that will be presented to the legal committee. Now, on confidentiality, here I beg to digress a little bit. There's always this perception that the ICAO Council is a court, and therefore, when it's performing these Article 84 functions, and therefore should be open to all states, at least all contracting states and the public, when it performs these functions. But we have a rule in the Rules of Procedure for the Council, Rule 37 of those rules and Appendix F, when read together, are to the effect that when the council is performing these dispute settlement functions, meetings should be held in closed session, which means that they're not open to the public, and the documents pertaining to those meetings should be marked as restricted, which means that they cannot be circulated outside the organization to unauthorized parties. On the other hand, when you look at Article 30 of the rules, Article 30 says that the council, the proceedings of, relating to disputes shall be open unless otherwise decided by the council. So you see that there is an inconsistency somehow between those rules. So there is a drafting proposal which attempts to reconcile these 2 provisions, which equally apply when the council is engaged in the process of settling disputes. And it is also important to note that this drafting proposal emphasizes the council's role in facilitating the negotiated settlements when it is dealing with disputes. There are some new provisions that the working group proposed. One of them deals with the council's power to indicate provisional measures when it is dealing with a matter before it. The idea is that sometimes, if you look at the nature of certain cases, there is the need to limit potential damage to and to preserve the rights and interests of the parties, or to preserve the safety and security of international aviation. And therefore, there is a drafting proposal in a new Article 34 to the rules, which would allow the Council to indicate provisional measures when the circumstances so require. There's also a new provision which would allow the Council to issue practice directions. Again, with the multiplicity of cases that we've dealt with these days, we've realized that there are many, many areas where even though we have rules, they do not provide specific guidelines on what to do. If at any point in time there needs to be a new rule and the Council has to convene a working group or the legal committee, this would take forever. Mind you, the working group has been at this for the last 5 to 6 years already, right, just to try to amend the rules. So the idea is to give the Council the authority to adopt practice directions. Of course, practice directions will not be rules. They would not amend the rules, they would not supersede the rules, but they would provide guidance on practical issues in respect of which there is no guidance presently. The working group came up with a list of potential areas that the Council may issue practice directions. Of course, these are listed here, but they are more comprehensively discussed in the report and in an appendix to that report, which, as I mentioned, will be published as a working paper for the upcoming legal committee meeting, the 39th session. The other major area where a new provision was proposed is in relation to the conduct of virtual proceedings. Of course, with the advent of the pandemic, which made it impossible to hold in-person hearings and proceedings, it was important, necessary to consider alternative means by which the Council can perform its Article 84 functions in the event that in-person proceedings are not possible. So a new Article 36 has been proposed, which would allow the Council to conduct virtual proceedings, of course, with certain safeguards in place, one of them being that the Council must have due regard to the availability to the parties of technological means for such virtual proceedings. The other one being that the Council must consult the parties before making any decisions on how to conduct, whether and how to conduct these virtual proceedings. The working group considered many other provisions, but decided that amendments were not warranted. Some of them are listed on this slide here. I will not go through them to bore you too much, and I'm seeing that I'm running out of time. There was one important issue that the working group discussed, how to interpret the term majority as used in Article 52 of the Convention. Article 52 says that decisions of the Council shall be approved by a majority of its members. Now, how do you determine a majority of the Council? Well, long story short, within the working group, some preferred an absolute majority. So the Council presently has 36 members. An absolute majority would be 50% plus 1, right? Others preferred a qualified majority in the sense that there are provisions that make certain Council members ineligible to vote in certain circumstances. For example, they may be party to the dispute, or they may not be party to the instruments in respect of which the dispute has been raised, the transit and transport agreement, for example. And therefore, that reduces the number of Council members who are eligible to vote. So if, say, you have 10 Council members involved in the dispute, the total number is no longer 36, but 26. If you insist on an absolute majority, it means you need 19 out of 26, but a qualified majority would be, say, 14 out of 26, or something along those lines. Despite the long deliberations, the working group could not agree on a specific amendment to this, and therefore, this matter is left for consideration by the legal committee because it would involve basically an amendment or an interpretation of Article 52 of the Convention, which is not part of the rules. So I'm out of time, but in terms of next steps, the report will go to the legal committee in June, As I have mentioned, it will be published in all ICAO working languages. The legal committee at its 39th session will consider the recommendations, and then it will make its own recommendations to the council, which has the ultimate authority to approve any revised set of rules. So thank you very much. I think I have come to the end.
Thank you very much, Dr. Nyampong. Now we will open the floor for questions and answers. We have about 10 minutes. Is there anyone who'd like to pose a question to Dr. Nyampong? I think if you're still considering, I'm going to pose one question, if I may. So you mentioned that in the revision of the rules, there will be the possibility of virtual proceedings. But I'm not going to ask you about that. You mentioned that the working group met virtually, especially during COVID-19. I was just wondering whether you could share some of the experiences on that with everyone.
Okay, that's a trick question from Siwe, as usual. The working group is a working group of the legal committee, and it does work within the rules of the legal committee. So within the rules of the legal committee, there wasn't any specific provision made for virtual meetings. The language is quite open. It says that the legal committee shall meet. Right, so the interpretation that we took of it was that the provisions do not necessarily outlaw the conduct of virtual meetings of subsidiary bodies of the legal committee. Of course, this was not without controversy. There were several states that were not in favor of the working group meeting virtually. So the compromise that the working group came to was that any decisions or any points that were agreed upon in a virtual format would be opened for reconsideration when the working group convenes in person and would then be finalized. And I believe this was how the working group was able to carry on its work in spite of the challenges brought up by the pandemic.
Thank you very much, Dr. Nyampong. Do I have any questions from the floor? Anyone? No, then if you don't mind, I'm going to ask you a second question. And the second question is this. You mentioned that these revised rules will be considered by the legal committee, and I said so myself. So would you have any suggestions to states on preparing for the legal committee session deliberation on the revised rules?
Yes. So the suggestion that I would have for states is that, number one, participate in the legal committee session. The legal committee is open to participation by all member states of ICAO. It's not like the other committees that are of limited membership. Legal committee is open to participation by everyone. So please make sure that your state participates. When you go back, start speaking to the people that make those decisions to make sure that they send you or they send someone else, preferably you, to the legal committee meeting, the session that is coming up in June in Montreal. So your presence there is number one, almost 90% of the equation. Secondly, all the working papers that will be considered by the legal committee will be published in advance of the meeting, and there will be a website set up. So all these papers will be available in all 6 ICAO working languages. So please make sure that you have downloaded copies of the papers, you have read them, you have done your internal consultations, and that when you come to the meeting, you are able to express your position on those papers, on the outcomes of the work that is presented for consideration by the legal committee. I'll leave it there.
Thank you very much. Does anyone have any questions? Yes, I see a hand over there. Could you identify yourself before you ask your question?
Thank you. Can you hear me? Yeah. My name is Jay Kim. Now I am working as an international affairs coordinator at the Supreme Court of Korea, and for the last 3.5 years, I worked as an alternate on the ICAO Council of the Republic of Korea. Thank you for the presentation, Mr. Nyampong. And my question is related to the current revision work of the dispute settlement regulations, rules on the dispute settlement. Actually, my understanding is that the character of dispute settlement under the current rule is usually regarded as a political nature's dispute settlement. But my question is that is there any suggestion to get more lawyers involved during the dispute settlement deliberations or dispute settlement discussions? Thank you.
Thank you. Thank you for the question. This was an issue that was deliberated upon at length by the working group. In the first few meetings, there were what the chair used to refer to as philosophical discussions about the nature of the dispute settlement function of the council, whether it is a judicial function or a political function. But after a while, the working group came to the realization that that discussion would really not help in resolving, the task that had been assigned to it. In the sense that whether it is a judicial body or a political body, it has certain functions and it must be able to perform those functions. Of course, the council is, comprises 36 member states, and each of those 36 member states has the discretion to appoint a representative and several alternates as they wish. Nothing stops the member states from appointing people who have, or representatives who have legal training when the council has to deal with a matter that is of a legal nature. But that is not to say that the council then becomes a court of law, strictly speaking, in that sense. In fact, the International Court of Justice in the Qatar case did issue a pronouncement to the effect that the concept of judicial propriety does not apply to the ICAO Council because the council is composed of representatives who are not sworn judges and so forth and so on. So again, there's that debate that goes on, but that, in the view of the working group, does not help in resolving, helping the council perform its dispute settlement functions as laid out in Chapter 18 of the Convention. In fact, that's why we no longer refer to the judicial or quasi-judicial functions of the council, as you would see in some of the literature, but we just call them dispute settlement functions. I hope I've been able to answer the question.
Thank you very much. Anyone else? I think there's a hand over there. Am I right?
Thank you very much. Posesi Bloomfield from Tonga. Disputes can also happen between less developed countries. In many cases, you would agree they would need the most help to protect their sovereign rights under the convention. So like any civil court of law, the prohibitive costs of bringing a dispute to the council can be a barrier or a disincentive for participation. So my question is, what measures, if any, have been considered to allow greater access by parties who have a dispute, a legitimate dispute, because otherwise this just becomes a mechanism accessible to some and not all members.
Do you want to answer that, or shall I? Please go
I
ahead.
can attempt by just saying that, while I'm I fully agree with you about the prohibitive cost. I must also say that the filing of an application before the council does not involve paying filing fees. Your costs are, elsewhere, but not in accessing the council. You may have to recruit, the expertise to write your application and your memorial, but you have to do that in any event because you need to present a case, right? But in order to access the council, you do not need to pay any money. In fact, even translations are borne by the organization. And in fact, this is a heavy burden. The translation of the documents that are filed in one ICAO language into the 5 other ICAO working languages are funded by the, the contributions of member states. That's all I'll say for now.
Thank you very much. Yeah, I was going to do the lawyerly bit and say that I think this aspect was not within the mandate of the working group, so we would not be able to give you really a comprehensive answer, but I think Dr. Nyampong has done a great job in addressing your question. So any last question? Otherwise, I'm going to move on to the next topic. There is one more? Someone? One last question.
Thank you. Good afternoon. I'm from China and working for the Civil Aviation Management Institute of China. I have a question for Dr. Nyampong. You just mentioned the working group identified relevant practice of other international dispute settlement bodies, especially the ICJ judgments. So I want to know how judgments of ICJ are used in IQ dispute settlement mechanism. Are they can be used directly as conclusion or just as important references? Thank you.
Again, a good question. So I should have issued a caveat in that regard to say that the benchmarking studies that were done were not in relation to the judgments of the ICJ in particular. What we looked at were the rules that apply to the ICJ when it does its job, right? As against the judgments issued by the principles of law that are established in the judgments issued by the ICJ. But I did refer to the decision of the ICJ in the Qatar cases because these were decisions that were made in relation to appeals from decisions of the Council. So under Article 84 of the Convention, the decisions of the Council are appealable to the ICJ, and the decisions of the ICJ from those appeals are binding on the parties. And therefore, we look to those specific decisions for guidance on what the ICJ says. And because the nature of the work was in relation to the rules applicable to the settlement of differences, we did not specifically look at the broader, principles of international law as, set out in ICJ decisions that have nothing to do with ICAO. Thank you.
Thank you very much. I hope that addresses your question. So we have to move on to the next part, but I want to thank Dr. Nyampong for such a great job in explaining the revised rules and the work that went behind it, as well as addressing all the questions. So before we move on to Dr. Lee, can I just ask for a show of appreciation for Dr. Nyampong? Thanks again. And then just before we actually move on, I'll just give a reminder that the revised rules, when finalized and approved by Council, will apply only to future disputes and not to the current disputes that are already filed before the Council. Thanks again. So now it's my pleasure to introduce Professor Lee Gunyang of the Korean National University of Transportation. Before joining this university, Professor Lee was in charge of planning and implementation of international cooperation and collaboration at the Office of International Program and Policy of MOLIT. He was the Republic of Korea's national coordinator for the ICAO USOP and has played a vital role in establishing and expanding aviation safety in this country. Before I hand the floor, however, to Professor Lee, I mentioned earlier that I'm going to give a rather long introduction. And the reason for this is that I'm also going to share some thoughts on the subject of how the Chicago Convention has worked over the last 80 years. And the reason why I'm doing that is originally we intended to have 2 speakers for this part of the panel. And so I exercise a bit of moderator license to say some words. It's going to take a few minutes long, so it's not going to be that short, but it's not going to be too long. So first of all, I will put my opinion right out front. I will say, I think the Chicago Convention has actually worked really rather well. And I will say that the reason for this is that it has actually seen aviation through ups and downs over 80 years. With only 2 substantive amendments, Article 3 bis and Article 83 bis. The aviation downs, including crises and shocks in more recent times, include Y2K, 9/11 in 2001, SARS, and our region knows that very well, in 2003, the financial crisis in 2008, the eruption of the Icelandic volcano with that really unpronounceable name, and that resulted in the closure, unprecedented closure of European airspace. And we thought that we had already seen that in 9/11. And then, of course, the B737 MAX grounding, the COVID-19 pandemic. Who would have thought that we would be seeing that 1 in 100 years event? Each time, thankfully, aviation has survived and bounced back. The convention has served as a cornerstone of international civil aviation regulation, fostering cooperation and standardization among nations. Over the decades, it has enabled the growth of air travel, ensuring safety, security, and efficiency in air navigation. The Convention has, with its principles of sovereignty, non-discrimination, and cooperation, provided a broad framework for promoting sustainable development, advancing technological innovation in the aviation industry, and resolving disputes, as you have just heard. Its enduring relevance underscores the adaptability to evolving challenges and opportunities in the ever-changing landscape of air transportation. So how has all this been possible under the Chicago Convention? Much has been written about the Chicago Convention. I just would like to mention a few factors that I think has contributed to its success. First, flexibility in setting standards and allowing for differences. The predecessor agreement, the Paris Agreement, actually made the annexes part of the agreement. And the trouble with that, or the challenge with that, is that if you become party to that agreement, and if you do that for the convention, then it makes ratification something rather more difficult for states to consider. And if they are made mandatory without any room for some kind of a, for want of a better term, escape clause, would really make states pause to become party to this convention. So it would not have been possible to obtain the almost universal adoption of the convention if the standards had been mandatory and there were no differences. It would also not be possible to continuously adopt practical standards to address challenges unanticipated in 1944, such as cybersecurity, climate change, unmanned aircraft, and other technological developments in a timely manner. Second, flexibility of the Council's remit and function. The ICAO Council may consider almost every matter, so long as any contracting state refers to it as a matter relating to the Convention. And the objectives of ICAO are, I would say, somewhat broad and flexible. Based on this, the ICAO Council, supported strongly and very ably by the Secretariat, is able to deal with emerging issues not foreseen in 1944, such as the sustainability issues that are now priority for us as an aviation community. And other issues like artificial intelligence, space-related issues, and other issues we cannot even imagine today. Third, and this I think is going to be a little bit controversial, but I'll say it with input from a good friend, avoiding traffic rights issues by leaving them in a way to out of the convention and bilaterally. The issue of whether ICAO should deal with air traffic rights or not almost dominated the discussions in the 1944 Chicago Conference and eventually led to the Bermuda system. Some say it was a failure of the conference and the Chicago Convention. However, actually, air traffic rights were dealt with at during the 5 weeks of the Chicago Conference and resulted in two separate instruments, the Air Transit Agreement and the Air Transport Agreement. And if you look at the record, if I may say, of the Air Transport Agreement, there are only, I think, about 11 states, am I right, that are parties. That tells you everything, I think. If you had included air traffic rights in the Chicago Convention, would we have 193 states today? I'm not sure. So considering the complex nature of traffic rights with the associated elements of national pride, security, among others, and the current difficulties in other economic international organizations, it may also well be that not including the air traffic rights in the Chicago Convention has allowed the convention the success that it has today. But above all, my view is that the greatest success factors are, one, the creation of ICAO. Without the organization ICAO, which operates under the able leadership of the Council and strongly supported by the Secretariat, we would not have the evolving standards to meet the challenges and the issues that were not faced in 1944 and that are not going to be faced today. So the continued relevance and increasing support of ICAO is evidenced by the huge participation in its events. And even today, the reference of disputes to the Council for resolution. So I think there are another two, I will end here and I will call upon Professor Lee to make his presentation. Thank you very much. Professor Lee, please.
Thank you, Ms. Tan, your generous introduction about the Chicago Convention and myself. Once again, I'm Professor Lee Young of the Department of Aeronautical Science and Flight Operations at the Korea National University of Transportation. It is my honor and privilege to deliver my presentation material in front of all distinguished participants and guests. In addition, it is also even more meaningful because it's the first international conference to be held since my election as a president of the Aerospace Policy Law Association in Korea. I can see many participants from my association. What I'm going to say is explaining about the relationship between the Chicago Convention and the Republic of Korea. And I'm going to tell you how the Chicago Convention is still ineffective even 80 years later. At the end of my presentation, I would like to talk about new concepts and technologies that need to be reflected in the international civil aviation treaties. As you're all aware, representatives from 54 countries were invited to Chicago at the end of World War II to work on creating an international agreement on international civil aviation. The Chicago Convention came into force in April 1947. At that time, the Republic of Korea was not in the list of the participants because we were colonized by Japan. As you can see in my slide, the Chicago Convention has been amended several times since its enactment. However, its spirit and the philosophy are still very effective. Among the amendments to the Chicago Convention, Article 3bis, non-use of weapons against civil aircraft in flight, is an amendment caused by an aircraft accident registered in the Republic of Korea, Korean Air 007, which was shot down by a Russian fighter jet. Since then, the number of interception accidents of fighter jets are significantly reduced. Let me tell you about the relationship between the Chicago Convention and the Republic of Korea. In the Republic of Korea, we ratified the Chicago Convention during the Korean War to recognize its importance in aviation field. Article 1 of the Korea Aviation Safety Act declares that Chicago Convention is faithfully implemented in Korean Aviation Act. This means that Republic of Korea is promoting safe operation by reflecting international standards and recommended practices by ICAO, and it is implemented in domestic law. Various aviation-related academic societies are actively working in the Republic of Korea. Among them, the most related to this seminar is the Korea Society of Air and Space Law and Policy. More than 300 scholars, lawyers, and legal representatives serve as members of that society. We publish paper books 3 times a year, and also we conduct presentations and discussions by holding academic conferences several times in a year. Although the Chicago Convention was created 80 years ago, it is still very active as an important convention. I would like to introduce some interesting articles. First one is Article 8, pilotless aircraft. The review of UAV, which has only recently been rapidly developed, and the concepts were already reflected in the Chicago Convention 80 years ago. Even though the concept is slightly different to advanced urban air mobility at this time. I will choose Article 14, prevention of spread of disease. Global pandemic was predicted 80 years ago at Chicago. And the COVID-19 was the biggest impact event in the history of air transport. The COVID-19 pandemic has caused an unprecedented crisis for air transportation industry and affect millions of aviation users and stakeholders. It requires a useful framework for a coordinated global response to future disease outbreak. From now on, I would like to tell you about the Chicago Convention, about the future to overcome. For the development of aviation industry, it is necessary to remove barriers. One of that barrier is airline substantial ownership and effective control. The nationality clause criterion has been used since the 1940s. Over the past decades, liberalization, privatization, and globalization have significantly changed the air transportation industry. States can liberalize airline ownership and control through various means. And I think ICAO can initiate the development of an international agreement for states to liberalize airline ownership and effective control area. There are also several measures to remove barriers. One of that is easing market access and utilizing multilateral convention, or some cases, interregional air transport agreement utilization. Aviation consumer protection is important for the development of aviation industry recently. The trend of selling and purchasing airline ticket is electronic means. There are various players such as airlines, ticket sales agencies, travel agencies, and consumers. Consumer damage is also caused by the collision between E-commerce Act and the Aviation Business Act. ICAO level rulemaking on electronic transaction of airline tickets is expected to be an important step toward better consumer protection area. The Chicago Convention to stop the spread of epidemic is very important concept. However, in the face of a global pandemic, such as COVID-19, air transport industries were very helpless. So we need additional solutions. Non-contact technologies, such as facial recognition, are critical to prevent the spread of infectious disease. The development of these contactless technologies and the spread of their applications through eye care are very important. Let's thinking about the artificial intelligence, which Ms. Tan already mentioned. New technologies using artificial intelligence are now beginning to be used in many parts of our society. Attempts are being made to allow robots equipped with AI to perform repeated and simple tasks instead of humans. These attempts are expanding into more complex and comprehensive fields, which we call strong AI. Legislative activities are needed to ensure that application of these advanced technologies in the aviation sector is important. Let me summarize my presentation with the slide. The Chicago Convention was created 80 years ago, but is still very useful and effective today. Second, the Republic of Korea recognized the importance of the convention even during the war, and our government ratified it. Third, Chicago Convention needs to be revised progressively to develop the air transport industry in orderly and effective manner. Lastly, the development of the Chicago Convention requires ICAO, government, industry, and academic experts to work together. Thanks a lot for your kind attention.
Thank you very much, Professor Lee. So we do have some time for questions and answers, but I want to make a suggestion. Instead of questions, I'm going to ask for thoughts and views from everyone on how the Chicago Convention has worked for 80 years. I'll just add that Professor Lee mentioned about, and many other people have mentioned about the standards and in relation to the revision of the Chicago Convention. I think the Chicago Convention, because of the annexes, not strictly speaking in the convention, but is considered to be part of the Chicago Convention, allows for changes to be made over the years. And one of the challenges is that actually we now have accumulated something like, that figures kind of vary, 12,000, 13,000. So the CAAs that have to implement them and the industry that have to, well, work under them, it is quite a lot to deal with, especially for the smaller CAAs where the resources are very few. So I think that's one of the challenges. I think the interesting thing is that because ICAO is aware of this issue, ICAO has in fact taken steps to try and alleviate and to address this challenge. The other thing that Professor Lee has mentioned is about collaboration and cooperation. And I think this is also one of the success factors, that ICAO and the Chicago Convention, rather, has allowed for an ICAO that focuses on technical safety and security standards and other technical standards. And it's this focus, despite or with political elements, that actually has allowed for ICAO to do a very successful job, albeit with difficulty, albeit with tight resources, and so on. But a marvelous job nevertheless. And I think that what's really important at the end of the day is the unity and cooperation that is incorporated and institutionalized within the institution of ICAO because of the provisions of the Chicago Convention. If you read the preamble, which was created in the time of war with the aspiration of peace and the development of the world, and non-discrimination, even though in a war there are winners and there are losers, right? But one state, one airline was the aspiration. What a marvelous aspiration, despite the fact that if you look at the circumstances in which the Chicago Convention was born. And if you look at the provisions of the Council, for example, mutual recognition, okay? Notwithstanding that the countries have differing resources and capabilities and so on. And if you look at Article 84 itself, the element of negotiation. I just recently was listening to a seminar on other dispute resolutions, arbitration in other international organizations. And one of the interesting elements is that Article 84 incorporates the need for negotiation. And I personally like the word difference rather than dispute. I think there is a difference in the connotation. And so I think we are really the beneficiaries of a treaty and an organization that was built on this treaty that has really made cooperation, collaboration the core of its existence, and that has allowed aviation to flourish. So I do see that our MC has come on stage. Does that mean that we have no time for any other contributions?
Maybe one or two comments would be okay?
Okay, thank you very
Yes.
much. Yes, anybody dying to contribute, it'll be great. Anybody? Your thoughts on the Chicago Convention and how it has worked for 80 years? I see somebody.
So thank you immensely to the panelists and the moderator for this interesting presentation. I'm Graham McFannell from the Department of Foreign Affairs of Canada. And I think I just want to take this opportunity to second Mr. Lee and his reference to Article 3 bis as a milestone of the Chicago Convention over the last 80 years. It demonstrated the ability of states to take on an important issue that wasn't covered under the convention, and I think is indicative of the fact that it is only one of two substantive amendments to the convention. So it really is an important milestone, and I think it's something that we can reflect on today as we discuss the importance of aviation safety. So thank you.
Thank you very much. I just want to underline that ICAO recognizes the importance of civil-military cooperation, and this has been part of its work over many years as well. Anyone else? No, I don't see anybody. Okay. In that case, I just want to underscore again the importance of the Chicago Convention and the extent to which it has contributed to civil aviation and the aviation community that we have today. So I think kudos to the founders and kudos to everyone, all present here and not here, who have made it work so well. May we all continue to collaborate, cooperate, and work through the difficulties. Never ever say that we cannot agree, and therefore we have to do something drastic. If possible, let us just cooperate, address the challenges, and bring aviation to greater heights. Thank you very much. And thank you very much to Professor Lee and Dr. Yao Nyampong for great presentations. Thank you very much. Thanks, everyone.